in August 2018. Was not there.
Was not.
Okay. Yeah. All right. Cool. All right. So, so yeah, I felt it best. Last time I know that I showed up and we gave a presentation, but I feel like a lot of people were still kind of left a little bit in the dark. They weren't really sure what was going on or what the history was behind it. And I think there was a certain degree of presumption on our part that people already kind of knew what was going on. So I figured it would probably be best if I give just kind of a recap of, you know, why we're all here. You know, why did this become an issue, and so on and so forth. So, so just to recap, this all started in 2016. There was a JDFPG contractor by the name of Scott Meredith. He allowed us to use his name. And he was unhappy with the tax situation. And so he started researching online to find a firm that specialized in international tax matters, in particular, handling matters dealing with private individual clients. And as he researched, he found one firm in particular that kind of stood out, a firm, Castro & Company. And he started doing some research into the founder's background, myself, John Anthony Castro. And just to give you a little bit of background about myself, just to kind of establish you know, my credentials. I'm a graduate of Georgetown University Law Center in Washington, DC, and I have a certification in international tax. And I also earned my Doctor of Jurisprudence from UNM School of Law, and I'm also an OPM Fellow at Harvard Business School. So suffice it to say, I'm very well credentialed. I know what I'm talking about. I also have 2 published books. One is called International Taxation in Plain English, and the other one is International Estate Planning in Plain English. The former of which is actually used as a textbook at the R.H. Smith School of Business at the University of Maryland. I also have over 50 published legal research articles, and I've been covered in magazines and newspapers in both the United States and Australia, including the Sydney Morning Herald. So on top of being well credentialed, I'm also well known and leading in the industry as far as legal research. So when Scott Meredith saw all of this back in 2016, he felt really confident that he had found the right firm. And so he contacted us, we spoke, and we agreed to look into his issue. So the first thing we did was we researched the issue, which I'll explain to you. So first, there's the 1966 Defense Agreement, which, by the way, is not a treaty because it was neither signed by the President of the United States nor ratified by the United States Senate. The Defense Agreement creating JDFPG was signed before income tax treaties were the norm. You see, under international law, wages, the general prevailing standard is that wages are taxed in the geographic area of performance where the service is actually done. And so what that means is back in 1966, before income tax treaties existed, if you moved to Australia to work for any company or even the US government, your wages would be taxed by the Australian Tax Office, the ATO. So when JDFPG was being created, America didn't want the staff of private defense contracting companies to be exposed to Australian tax. And so they negotiated this agreement. Australia felt uncomfortable giving up their inherent right under international law to tax wages earned within their borders. And so they wanted an agreement that, that the income generated by anybody that worked at JDFPG would be, and the quote was, brought to tax in the United States. So because the 1966 Defense Agreement was not an actual treaty, they realized the only way to effectuate it was on an individual contractual basis. So each American assigned to JDFPG had to sign a contract agreeing not to claim the foreign earned income exclusion, what you've come to know as the closing agreement. So in exchange, the Australian government agreed that they would not tax anybody's salary if they signed this closing agreement. So it sounds really simple and straightforward, and it was for a couple of years. But here was the actual problem. What America negotiated with other countries was actually a much better deal. In most other places, we had negotiated a total exemption for Americans without any conditions. So no closing agreements or anything like that. In 1966, the Johnson administration really bombed this negotiation. Even though Australia wasn't really in a position to negotiate, considering that there was really nothing in Alice Springs, prior to JDFPG. The economic incentive alone of a U.S. base was more than enough to negotiate a no-strings total exemption. So, and another thing is that a lot of contractors only take foreign assignments for the tax benefits. With Internal Revenue Code Section 911's foreign earned income exclusion, you get to exclude $105,900 of your salary from U.S. taxation on top of the housing allowance and a lot of other perks, which can really bump up the tax-free nature of that benefit to about $150,000. That's the equivalent of earning $200,000 stateside and then having to pay 30% federal and state tax. So the Johnson administration should have known the foreign earned income exclusion was critical to the talent retention strategy of private defense contracting companies, but the Johnson administration wasn't exactly known for its business acumen, so, oh well. Given the fact that the Americans in 1966 negotiated a horrible deal with the Australian government, JDFPG started having difficulty attracting talent to the base once people learned about the tax issue. Yes, it's still good for your career to accept a short-term assignment out here, but the main incentive for living in a remote area outside of the US was really the tax benefits. So even after focusing a lot on psychology-based data to ensure they hired the right people who could live happily in a remote area, there was still a shortage of talent, especially for those making far beyond the exclusion amount that really needed to claim the foreign earned income exclusion to justify taking the position. Because in some cases, your after-tax position at another base would have actually been higher than having to be exposed, to U.S. tax on your salary out here. So what did the folks at JDFPG do? Did they try to negotiate a better deal with the Australian government? Nope. Instead they saw it easier just to not tell anybody about the tax issue until that person had already passed kind of the point of no return on taking the position. So that, in the legal world, has a very specific legal name, and that's fraudulent inducement, fraudulent misrepresentation, coercion, and duress. That, any one of those in and of themselves automatically by operation of the law invalidates any contract, regardless of whether that contract is with the local car salesman or with the governments of Australia or the United States. The government has no more of a right to fraudulently induce or coerce anybody into signing a contract than used car salesmen. But that's the path they chose to resolve the situation of being unable to attract quality talent to the team at JDFPG. That was their first mistake. In the late 1970s and early 1980s, a new trend started in the world of international law. Governments began signing what's called bilateral income tax treaties to resolve taxing matters. It was a much better system than the domestic laws of two countries being applied to a single taxpayer, which in the past had created nightmare situations of double tax, where your tax rate could easily hit 70 to 80% because both countries were trying to tax you. So tax treaties either assign taxing rights to the country of source, where the income was coming from, the country of residence, where it was actually received by the taxpayer, or a particular government when dealing with government functions and government employees. These treaties were negotiated and drafted by members of the Congressional Joint Committee of Taxation, which consists of US representatives and senators who have experience with tax matters. They are then presented to the President of the United States for his signature, and then they are presented on the floor of the US Senate for full ratification by the Senate. Then and only then, the treaty has the full force and effect of law in accordance with US law. In 1984, the United States and Australia signed such a treaty. Formally titled the Convention between the Governments of the United States of America and Commonwealth of Australia for the Avoidance of Double Taxation and Fiscal Evasion, but it's informally just called the US-Australia Income Tax Treaty. It assigned taxing rights for a variety of articles of income, just like any income tax treaty. So as usual, dividends and interest taxable in the country of residence. Social Security is only taxable in the country of source. Private pension distributions only taxable in the country of residence, and so on and so forth. On the topic of wages, as usual, there are different articles for dealing with income from services that benefit private companies versus income for service to benefit governments. In some treaties, this article is limited to income directly from the government while employed by the government. So you'd have to actually be employed by the government. In other treaties, however, this is extended to private companies that are performing government functions like military research and development, surveillance, and digital intel acquisition. The Australian Income Tax Treaty is titled Governmental Remuneration. Now, the reason that these semantics are important is because the term governmental is an adjective. Other treaties use the term government remuneration, which is a noun. In those cases, it's clear they're referring to people directly employed by the government. However, when an adjective is used, it means government-like services being performed by a private company. This is supported by the fact that the technical explanations to the US-Australia Income Tax Treaty specifically state that it extends to individuals performing government-like functions. While this is still implied and not directly stated, it's obvious to any legal reader that Article 19 extends to employees of private defense contracting companies. It was this treaty that changed everything in 1984. As of 1984, none of you were supposed to sign contracts waiving your right to claim the foreign earned income exclusion. Despite the fact that your employment contracts specifically state that your company would not provide legal tax advice, their actions were the exact opposite. They told you to sign the closing agreement or risk losing your position. Some even said that it was a legal requirement to sign because there was a 1966 defense treaty, even though, as I explained previously, the 1966 defense agreement is not a treaty. It's just an informal, unenforceable agreement. It can only be enforced by contract, hence the closing agreement. They doubled down on the coercion and fraudulent misrepresentation and provided incorrect legal advice. That was their second mistake. This continued for 33 years until 2016 when Scott Meredith contacted our firm. Scott was pretty convinced that something was not right, and after we completed our thorough and very meticulous legal research, it turned out that he was right. We were very convinced that we were correct after we researched the law, and we informed Scott that we would be submitting amended US federal income tax returns to claim the excess tax that he had paid. But we also let him know about the statute of limitations. The statute of limitations says that you can only amend your returns going 3 years back. Further than that, you generally cannot amend. Scott then asked, well, who's liable for all the years prior to that 3-year look-back period? Normally, our answer in any type of that situation would be, well, no one's liable. But in this unique case, the companies at JDFPG actually committed the fatal error of providing legal tax advice that turned out to be incorrect. And there's a term for that also in law, negligence, which creates liability. We learned that we first have to beat the IRS in US federal court on this matter. Thereafter, to the extent the ATO gets involved, we also have to beat them in Australian federal court. Then and only then, we can file a class action lawsuit to cover all of those years that are outside that 3-year look-back period. So this would cover roughly 1984 to 2015. So for Scott, we filed amended US federal income tax returns to claim the treaty benefits to which he was entitled, and he ended up getting amended refunds for, I think it was close to around $60,000 for all 3 years. It was roughly around $20,000 a year. Surprisingly, the IRS didn't even put up a fight. It was like literally within 6 weeks, they cut a check and mailed it off to him. Scott then explained to us at that time that there were actually hundreds of other Americans in the same exact situation out here in Alice Springs. And so that's when we scheduled our first conference here back in August of 2018. After our conference in August, the IRS actually very unprecedentedly scheduled a counter conference in late 2018, and several defense contracting companies bizarrely began leaking confidential taxpayer information in order to what we believe was to retaliate, which is actually a huge felony criminal offense in the United States. As a result, the inspectors general for several agencies had to intervene. Several careers ended. but that's a separate story. Suffice it to say, everyone now understands that there are rules to play by when you're handling confidential taxpayer information. After that, hundreds of you came on board, and we identified that we reached the point of critical mass where victory was pretty inevitable. Shortly thereafter, the international division of the IRS became pretty enraged and sent the matter for legal research to their legal department in Philadelphia. Our firm was contacted by IRS attorney Brett Lamore, who told us that the legal research department had actually concluded and agreed with our firm's position. It was a really exciting moment for the firm. Hundreds of thousands of dollars were being refunded back to those of you that work at Pine Gap. We were preparing to truly just ride off into the sunset, yet another issue, resolved by our firm. But then the IRS unexpectedly struck back. The international division was furious with the legal department's conclusion, and so they contacted the office of the chief counsel at the IRS, and they demanded action. They then began reopening all prior approved cases and initiating examinations. In many cases, the IRS examiner actually agreed with our legal position. For example, IRS examiner April Salinas expressly said that she agreed with our firm's conclusion, but she stated that her superiors were forcing her to rule against us and to assess tax, which that in and of itself is a huge violation of the Internal Revenue Manual, because it very clearly states that superiors are not allowed to interfere with the discretion of examiners. So the fix was in before the clients even received the examination notices, and it was being orchestrated from the top by those who missed the fact, and I'm referring to the international division of the IRS, by those who missed the fact that the 1966 defense agreement was not a treaty, the closing agreements were legally flawed, and the 1984 income tax treaty is what actually applied. And with their credibility and their careers on the line because of this huge thing that they overlooked for more than 30 years, they then decided to treat each individual JDFPG refund claim that our firm had submitted as a separate case, and began assigning examinations to examiners all over the United States, from California to Florida to New York to DC and even Puerto Rico, which was pretty odd. And what we realized is they were really hoping that somebody in the international division would try to find some way to invalidate the claims that we had submitted. Thankfully, as a result of this, in early 2019, we got a denial letter for about 3 or 4 clients, which allowed us to file our first set of cases before the United States Court of Federal Claims in Washington, DC. We're also preparing to file another case next month before the United States Tax Court. Having this issue before 2 different courts increases our odds of success, and we actually need only win in 1 jurisdiction in order to have a solid path to victory for all other cases. There's also a 3rd avenue that we're strategically reserving, which is the United States District Court for the District of Columbia. So that means that even if we were to lose the other 2 cases, which I really don't think we would, I don't think it's possible, there would still be a 3rd avenue for us to go through. So just to let you know where we're currently at right now, we're projecting a victory in the U.S. Court of Federal Claims sometime this year in 2020, as well as the U.S. Tax Court. We're expecting a victory in Australian Federal Court sometime in 2021. We're expecting the governments of both countries to file appeals, which we believe will be resolved in 2022, which will result in the final conclusive class action that we file most likely in 2023. Just trying to give you a realistic projection of the time frame that we're looking at. So the wheels of justice turn very slowly, but they are turning in our favor. As is standard, DOJ Tax Division was assigned to the cases. Even they're having a hard time defending the IRS's position, but they have not rebutted our position on the 1966 defense agreement. But they are digging in their heels on the closing agreements and claiming that they're valid, even though they have no direct knowledge of how those signatures were acquired. Mainly because DOJ is obligated to defend the IRS's legal position, regardless of how ridiculous it may be. So long story made short, they will lose. It's just a matter of time. But now we have John Winter at the ATO, who's been sending out letters threatening to assess tax against people. It's going on like 3 years that they've been with this bark. So just to let you know, we are ready and able to immediately sue in Australian federal court on that issue. We've been telling John Winter to put up or shut up for about 2 years now, and it looks like somebody just got a letter, and it was another letter stating you need to file an amended return and return this money to the IRS or we're going to assess tax. So, I mean, the bargain just turned into an actual document, but we've yet to see any actual assessment. So the ATO is bound by the terms of the 1984 US-Australia Income Tax Treaty. If they rule against that, they risk the US Treasury and IRS retaliating and doing the same and imposing tax on their diplomats in DC, which I'm actually personally prepared to lobby for in DC if they decide to go down that route. So we've also reminded the ATO that it was our firm that protected Australian nationals in the United States 7 years ago, and actually even continuing to this day with regard to their superannuation funds, separate issue. So we're hoping to leverage that goodwill that we've built with the ATO to our benefit on this issue, but gratitude is very rare in politics, so I'm not banking too much on that. So that brings us to today. Why are we here? The ability for you to amend your 2016 US federal income tax return is 3 years from the due date. The due date for the 2016 return was April 15th, 2017. 3 years from that is April 15th, 2020. It's coming up in 3 months. So if you don't file an amendment before April 15th in 3 months, you forever lose your right to claim back the excess tax that you paid to the IRS in that year. And it won't be covered by the class action because the defense contracting companies will correctly argue that you could have filed an amended return to mitigate your damages. And so that means that you're going to lose out on that entirely. So now for the unpopular topic. These kinds of cases that affect a lot of people from a business perspective operate in almost the same manner as an insurance company. The only way it works is if everybody joins in. We pool the resources together, and that's how it makes sense for our firm to continue from a cost-benefit perspective. If everybody starts filing on their own and then only comes to us after they get audited, it really doesn't make sense for us. Why would it's the same reason why insurance companies say, why would we underwrite somebody that has pre-existing conditions? It's the same as saying, why would you buy a stock that you know is about to tank? It's a guaranteed loss. You have to net the upside against the downside and still be net positive in order for it to make sense. That's just how business works. So if you file on your own, then you've made the decision to be on your own, and you have to stick with that decision. When people stay from the group, it weakens the group and it jeopardizes the objective. To put it bluntly, it's a self-centered act of greed. And we do not want to work with anybody that went off on their own. If you're currently under examination for having tried this on your own, and that's why you're here, we'll take your case if and only if you pay the same fees that anybody else would have paid had we originally handled the case. That's how pooling resources works and allows us to pursue this case. So the first step, So the first step in dealing with this going forward, because I know some of you actually just got here, is we have to submit a Form W-8-BEN to the company, whatever company it may be that you work for. A Form W-8-BEN is the formal way that you claim treaty benefits, and it gives notice to whoever is the withholding agent, whoever's responsible pretty much for determining the tax issue. So we give this over to your company, and it states that you are claiming under Article 19 of the US-Australia Income Tax Treaty that you are exempt from Australian withholding taxes. That's what legally binds the company and prevents them from imposing withholding tax. And if they decide to disregard it at that point, now there's an injury under US law, even though it's just a temporary withholding tax, because they've been provided with accurate documentation, claiming a treaty benefit, and to disregard that creates an automatic injury that then the judge can come in and immediately review and resolve. Thereafter, we handle, if there's any prior tax returns, as well as the upcoming 2019 US federal income tax return, and you get a refund of anywhere from $20,000 to $30,000. So that's pretty much the process, the history of everything that's been going on and where we're currently at. So now's the time that I kind of wanted to open it up to see if anybody had any questions. Yes.
So, if you go to the IRS website, it has that blurb about, do you know how to answer questions that people ask, and I claim this, can I do this? So are you saying that is not correct? I mean, they specifically say on your website that cannot claim that 9/11 mentioned.
Correct, yeah. Yeah, we were aware. It was in the middle of litigation that they decided to put that out. And I'm glad you brought that up because we had talked about it as a group and they wanted me to explain this. So I've done a couple of lectures at international tax conferences and law school setting environments. And one thing I love to explain to people that are going to graduate one day, become tax attorneys, or even current tax attorneys in the international tax community, is I explain to them what it means to be an adversarial legal system, which is how you describe the US legal system. So what an adversarial legal system means is we have 96 United States district courts across the United States. So for example, I'm from Texas. We have 4 district courts in Texas. There's the United States District Court for the Northern District of Texas, Southern District of Texas, East and West. Smaller states only have 1. In order to sit and preside on this court, you have to be nominated by the President of the United States and confirmed by a majority of the United States Senate. And then you get a lifetime Article 3 appointment to sit on this court. So there's 96 of these people, and there's no question, extremely intelligent, best credentials. That's why the president nominated them. That's why the Senate confirmed them. Among these 96 federal judges, they can't agree with each other. And so for that reason, we have 13 United States Courts of Appeals. It's the 11th, or the 1st to the 12th, as well as the United States Court of Appeals for the DC Circuit in Washington, DC. And again, to get on this court, you have to be renominated by the President of the United States and reconfirmed by the United States Senate. So you can bet that out of those 96 that have already been presidentially nominated and senatorially confirmed, they're now picking the best of the best to sit on these courts of appeals. And even these courts of appeals can't agree with each other. You know, you have the 9th Circuit out in California that's very liberal. You have the 4th Circuit out in Georgia that's very conservative. They can't agree with each other. And so for that reason, we have the United States Supreme Court. And again, to get on this court, you have to be renominated by the President of the United States and reconfirmed by the United States Senate for a 3rd time, which we just recently saw with Justice Kavanaugh, extremely contentious and sometimes, razor-thin voting margins. And even these 9 justices that sit on the Supreme Court can never freaking agree with each other on anything. And the point of explaining all of that is to say that a lot of people think that law is a science. And I know a lot of you are engineers, and so to you it's like 1 + 1 = 2, there's a clear answer. That's not how it works in law. In law, it's almost an art form because art is in the eye of the beholder, so is law. It means that 2 justices, both of them either went to Harvard, Yale, extremely well-credentialed, nominated by a president 3 times, confirmed by a Senate 3 times, they can look at the same exact law and see something entirely different. And so the point of that, again, is that law is in the eye of the beholder. 2 very intelligent, reasonably minded people can look at something and disagree. That's why we have neutral forums where there's a neutral arbiter of fact and law that we call a judge, and he's the one that makes the final call. But even we know that sometimes we have a better shot at a case when we know that the judge was appointed by Bush versus, oh, this one was appointed by Clinton. So what it means is judicial philosophy comes into play, their background, their ideology comes into play, all these factors come into play in determining and trying to calculate, how they're going to come out on an issue. But what that means for us is in an adversarial legal system, you have 2 parties that have to very aggressively advocate for their clients. So you have law firms in the private market that advocate on behalf of taxpayers. And we will take the most favorable interpretation of a law that's reasonably possible. And likewise, the Office of the Chief Counsel of the Internal Revenue Service, their client is the United States Treasury. Their job is to generate revenue for the US government. So they're going to take the position that's most favorable for the US government to generate revenue. So they're going to argue for a very limited interpretation of Article 19. If you're not employed by the government, it doesn't apply to you. When there's disagreement, which there always is, that's where we go to court. But an IRS webpage has no more force and effect of law than one of our blog articles. So it's something worth looking into. You know, we always love it when the IRS puts out anything, whether it's a private letter ruling, it could be a revenue ruling, a general counsel memorandum through the Freedom of Information Act, whatever it may be. You know, we always look at what the IRS's perspective is, just to make sure that, you know, we're covering our bases and that, you know, there's not some case that we didn't take a look at. But in this case, we have thoroughly researched everything. We've concluded that the law is most definitely in your favor on this issue. But yes, the IRS is doing their job, and they're advocating on behalf of you know, the tax-favored legal position. Yeah.
John, I just want to make sure I heard this correctly. The treaty signed in 1983. The word governmental, which describes what we're doing, made the closing agreement unnecessary, as in like we shouldn't have signed it in the first place, it shouldn't have offered it. Correct,
yeah, because when the 1966 agreement was, I would just say, agreed upon, the idea was that income tax treaties weren't really prevalent at the time. I think there was only 2 income tax treaties that existed at that time, very obscure countries for separate diplomatic reasons. But that's why they had to negotiate, I believe it was Article 9 in the 1966 Defense Agreement, so that they could resolve the tax issue. But that was only signed by the Secretary of State and the Secretary of Defense at that time. It wasn't signed by the President, it wasn't ratified by the Senate, so it doesn't have full force and effect of law under US law. But it was the agreement to at least get the ATO to concede to not tax the wages of Americans out here. But what happened is when they signed the very comprehensive 1983 or 84 US-Australia income tax treaty, that one was actually signed by the Secretary of the Treasury, the President of the United States, and ratified by the Senate. And so that's the one that actually controls, and because Article 19 was on point, governmental remuneration, that's what effectively covered the base. But at that time, I think everybody was missed it.
So even if they gave us plenty of time, because they presented it to us 6 months prior to coming out. Even then, it'd still be invalid. Not worth it.
Correct. So even if it, let's say, you know, it's in the job posting when you first see the job offer. So there's no coercion, no duress, or anything like that, or there's still misrepresentation of law because they are communicating to you that it's a legal requirement that you have to sign this, or else the ATO is going to tax you. So clearly you don't want to have to pay Australian tax, and so you sign. And whether it's negligent or intentional, whatever it may be, the point is that there was misrepresentation involved in the acquisition of the signature, and that invalidates the contract. And so, you know, because, and that's something that several examiners picked up on, and they were like, you know, in individual audit cases, they were saying, well, give us specific examples of how this person felt, you know, coerced, or felt that they were under duress when they signed. And we said, look, we'll be happy to provide those examples, but even if there was none, there's still misrepresentation of law that automatically invalidates the contract. Oh, so sorry.
So in that case, I was told it was conditioned by employers coming out and signing. How would I ever prove that? Because it was all done with power.
Well, I mean, in those type of, you know, he said, she said cases, the presumption is actually going to be in your favor. So it's on the IRS to prove otherwise. And it has to do with like this term called burden of proof. And so when somebody comes up with an affirmative defense and says, hey, there was misrepresentation of fact or misrepresentation of law, and that's why I was induced to sign this agreement, that shifts the burden of proof now to the government to rebut that and to try to argue that there was no misrepresentation. So, which they're finding out the hard way in court, and they're realizing it's difficult, if not impossible, to do, especially because what the judge in that case is looking at is, if we've concluded that the income tax treaty applies, why on earth would anybody agree to forego the foreign income exclusion? It just doesn't make any sense. So clearly, there had to be some degree of implied misrepresentation. So there's definitely no direct proof, but I mean, the circumstantial evidence is glaring. And the judges are allowed to look at that and consider that.
So you currently know that we have an adversarial legal system. Has any neutral party judge agreed to go first?
Not yet. That's the cases that are pending right now before the U.S. Court of Federal Claims in D.C.
How long has it been pending?
It's going on about 7 months. It takes time. The IRS requested 4 extensions of 90 days. Or no, the first one was 30, then it was 60, then it was 90, and then the judge finally got tired and was just like, you guys need to submit a reply, like now. Even though we had been objecting to each extension they were requesting. So it's actually scheduled for hearing in July. So that's one of the reasons why we felt that it was imperative that we come out here, because that's after the April 15th deadline to lock in the 2016 refund claim. So, yep, it's going to be, the final decision is finally going to be in July. That's pretty much what it's scheduled for. So we'll finally have a decision on that. And like I said, I'm pretty confident that we're going to win. And then after that, we're also have a case that we are just filing in the United States Tax Court. And the reason for this is it's very technical. You can't file, and I'm glad you brought this up. Our hands were tied for the longest time. We wanted to get this issue before a court, but we couldn't because the IRS had never issued a formal denial or a reversal of the approved amended returns. And the way that it works in the federal legal system is you have to have a concrete injury before you can file a petition with the court. And so all we had were threats. But you can't just file a lawsuit in court and be like, oh, this person's threatening me. Like, that's not how it works, especially when it comes to tax issues. So they said, well, somebody has to do something. They either have to deny your amended return, but they didn't, because we submitted the amended returns and then they started approving them all. And then they initiated examinations, but now we have to wait for those examinations to conclude. And a lot of those examinations took up to 6 months because the examiner kept on asking for an extension of time to respond. I mean, we had submitted all the documentation real quick, but then they just decided to sit on it. And we knew what they were doing. They were just dragging it out and knowing that, well, unless they issue an actual denial, and then even when they issue a denial, they have to send what's called a statutory notice of deficiency, and then that's what they call a 90-day letter. Now you can actually take the matter to court. And so that's what we barely had in around January of 2019. We finally got a formal denial, so we're like, finally, and that's when we then filed in court. But then DOJ has 30 days to respond, and then on the 29th day, they said we need another 30 days. And then 29 days later, they said we need another 60 days. And then we kept objecting to the judge and being like, Your Honor, like, they keep on, asking for more and more time. How long does it take to draft up a civil response? And then they asked for a 90-day extension. And before we could even file an objection, the judge approved it. And then we got pretty upset and we asked for an actual hearing. And then I guess the judge wasn't really paying attention and realizing that he was just rubber stamping all the requests for extensions. And so he finally put his foot down and told the IRS, you need to freaking respond. We didn't seem to catch you that you kept on asking for these 30-day extensions, which, just those 3 alone added up to, about half a year. So it's been a lot of delay tactics, that have really dragged this out. But, all the delays have been on, the government's side. But like I said, now it's finally scheduled for a hearing, so we're finally going to get that resolution in July.
How many actual court cases do you have for verification?
Right now it's 5 in the United States Court of Federal Claims, and it's 1 is about to be filed in the United States Tax Court. Our Director of Litigation, Catherine McGann. No. So Yeah, she's not here because she has court hearings and things like that, which conflicted, and we had already changed the date once with y'all, and so we didn't want to have to do it again. And then I started sweating bullets because of the whole brush fires. And I was just like, oh my God, I really don't want to schedule it, like have to reschedule again. They're gonna think like we're flaking out. But, so yeah, we just decided, you know, we're gonna suck it up if there's smoke and deal with it. But, yeah.
So you can't be the only part of Australia that's not burning today.
Yeah, we're heading to Sydney next, so we'll see how it is out there.
So now the company's official direction that we are not required to sign the closing agreement. So I've already signed the closing agreement for the first year and getting ready to start my second. Does that mean that prior, like you said, the first thing we have to do, how do we handle the original closing agreement that we had to sign?
Just to put it really straightforward, the closing agreements, none of them are enforceable. It doesn't matter if you voluntarily signed, whether there's coercion or duress. There's,
Oh, there definitely was.
yeah, but yeah, even if there wasn't, I mean, there's flat out implied misrepresentation of law. There's a gross misunderstanding, and the courts understand that now, and that's why the judge is very anxious to hear this case, because, yeah, I mean, everybody's been, and trust me, I know how you guys feel. You're just stuck in this limbo state. You know, you're being told by the IRS, you know, no, you can't. We're out here for the second time saying, yes, you can. You know, we have cases, you know, where we actually have victories for clients who got their money back. The IRS said we agree with the Cashman Company. Then another arm said, never mind, we don't. Now we're assessing and we want that money back. So, yeah, it's the definition of FUBAR. But like I said, you know, thankfully it's all finally, you know, coming to a close. But that's why I also gave the projection about the time frame. Just because we win in the U.S. Court of Federal Claims, it's not the end of the story. The IRS is most likely going to file an appeal, and that's going to go to the United States Court of Appeals for the Federal Circuit. And if we beat them in the United States Tax Court as well, then they're going to appeal it to the United States Court of Appeals for the DC Circuit. And time frame on submitting briefs on that is 3 to 6 months for both sides, and that's almost a whole year. So that's why we're saying that we're expecting the appeals to probably not be resolved until 2022. Now we have John Winter to deal with, which Australian bureaucracy is even slower than US bureaucracy. So before he finally issues an assessment, if that's actually his real intention, we probably won't have, because even after he issues the assessment, then under Australian law, we have to engage a firm to then file a formal administrative claim of refund. That can take 3 to 9 months to get resolved. And then once the ATO makes a final decision by the actual head commissioner, then at that point, we can actually then go to Australian federal court. Now it's a whole other year for that to get resolved in the legal system here. So that's why we were projecting most likely an Australian federal court victory late 2021, and then a resolution of all the governmental appeals in 2022. And then once the dust all finally settles, it'll most likely be 2023 when there's that final decision. And now it's like, all right, the courts have agreed with us. Now we need to resolve 1984 to 2015. And that's going to be the class action.
So another pretty obvious question. What happens if we lose and all these people in the front have
Yes, yeah. So in the event that the IRS were to win, it's not going to happen. But in that apocalyptic scenario where suddenly international law is flipped on its head, then in that case, our firm, so that's another important thing to bring up. So our fees are contingent. And what that means is they're not just contingent on the result, they're purely contingent on maintaining that result. So in the event that we were to get you a refund back and we take our fee and the IRS changes its mind and we end up losing 2-3 years from now on appeal, we would actually return that fee back to you. You would still be on the hook for the base tax plus like a 1.5% interest rate. Yeah.
6 years from now.
Oh, you'd have to pay, yeah, you'd have to pay the IRS.
No, that's fine.
Oh, our fee, yeah. Oh, yeah. It's purely contingent. And we structure our engagements that way because that's what, so the biggest fear with contingent fees with the IRS, because the contingent fees back in the 90s, they used to actually be banned. The IRS didn't like it. And it made sense. You know, the IRS was concerned that it would only encourage aggressive tax planning. So attorneys would take really aggressive, unreasonable legal positions just to generate a big contingent fee, and then, you know, just pocket it and not have to deal with the issue. I looked into that, and even after, so there was one firm in DC, it was in early 2000s, they were charging contingent fees, irrespective of the ban on contingent fees. The IRS challenged them, and it went to the United States District Court for the District of Columbia, and the law firm actually won. And the district court, the federal court, declared that the ban on contingent fees was actually an unconstitutional administrative act by the IRS, so they couldn't do that. And so the IRS started really panicking on that one. They decided not to appeal because they don't want to bring any more attention to that case. It was Ridley v. Liu. So I looked at that case, I looked at the reasoning in the brief that the IRS had submitted, and I understood where they were coming from. Like I said, they were concerned that it would encourage very aggressive tax planning. So what I thought of at that time was, well, if it's a purely contingent fee, then it neutralizes that issue. Because a purely contingent fee means that in the event that the legal position is reversed, the firm has to return the fee. So now you have to, if you're the attorney, you have to say, okay, I want to advocate for, you know, the most favorable interpretation of my client, but I don't want to push the bounds too much and then get a fee now, but then have to return 2 to 3 years from now when the IRS ends up challenging it and possibly reversing it. So that's the reason that all of our engagements are structured as purely contingent fees. It's a way of us putting a check and balance on ourselves to make sure that, basically, to self-reflect and ask ourselves, are we really sure on this, that it's not going to come back and bite us? And if we're absolutely sure, then we proceed with the claim, because if not, we're exposing ourselves. So we're that confident, pretty much, in the legal position that we're willing to put, you know, our fees on the line.
Personally, thanks for coming down here. You know, there's a lot of people that aren't here that should be here, but there's a lot going on in the world that requires them not. Secondly, you guys are all overdressed. Appreciate you getting all dressed up, but it's Dallas Springs, so we're pretty casual. My main question is, why does the ATO care about our taxes? And why does John Winter even worry about it? He's not going to get any money one way or another.
Yeah.
If we have more money in our pocket, then we will spend more money on Australia, so we'll get more money. So what's the motivation for going after us? Other than this,
I mean, I think he's taken his orders from the Department of Defense with Australia. I think their perspective is they don't like the idea that you're going to end up being tax-free. You're not paying tax here, you're not paying tax there. So from their perspective, it's double non-taxation. I mean, that's a big deal. Like that's like what Apple did when, you know, they set up that company in Ireland that wasn't a tax resident of Ireland, and then wasn't subject to U.S. tax, and then it was actually, you know, directed out of Bermuda and shifted billions of dollars out there. So they kind of feel like it's abusive, in other words.
like any other deduction you take.
Yeah.
Family
Yeah.
mortgage interest. Right?
Yeah. I think he just doesn't seem to understand that the foreign earned income exclusion has been in the code since 1954. You know, it's not some loophole. This was specifically and very strategically designed by the U.S. government to encourage Americans to work overseas. It was to incentivize it. And so, and I think I think he just feels that perhaps, you know, that the U.S. government's pulling a fast one on them. You know, it's like, you know, they agreed that as long as, you know, Americans, you know, decided to contractually sign away the foreign earned income exclusion, they would say, okay, we're not going to tax your wages. And now we're coming back later saying, oh, actually, there's this income tax treaty, so voila, there's no tax anywhere, and you can't tax me, and they just kind of feel wronged by that. Also, I think when they negotiated Article 19 of the U.S.-Australia Income Tax Treaty, I don't think they had JDFPG in mind. I really don't. I think they were thinking about diplomats working in Sydney, and American diplomats in Sydney, and Aussie diplomats in DC. I don't think they were particularly thinking about JDFPG. But I mean, arguably they could have, just because, again, why would they have added governmental remuneration and then use the exact phrase government-like services? I mean, you either work for the government or you don't. If you're saying government-like, then you're clearly saying this person doesn't work for the government, but he's still performing government-like function. So that's where it's just really confusing. You know, that nobody caught this, that Article 19 applied to JDFPG and it just went unnoticed for 33 years.
And so expats get similar benefits that we try to find?
I'm sorry?
Do their expats in DC get similar benefits that we get for student income?
I don't know if the Australian government exempts, has something similar to a foreign income exclusion, but they do claim Article 19. So Article 19 is their diplomats that are working in DC say that, yeah, I'm living in DC. I've been here for 6 years with my family. I work at the Australian embassy, but I'm not exposed to US tax because Article 19 says I'm here engaging in government-like services, you know, of diplomatic nature, and therefore I'm exempt from US tax. So, so yeah, they're not, I mean, whether they do that or not, I mean, the benefits there, just kind of like out here, nobody was really aware that Article 19 extended to them, you know, until we brought it to their attention. But I mean, that's just the nature of income tax treaties. I'll be really straightforward with you. When I started the practice, I was really surprised the amount of things that we consider tax treaty law 101, the vast majority of people just weren't aware of. And I was really surprised by that. You know, I would ask people things like, this deals with the United Kingdom, but I ended up finding out people didn't know about straightforward things like, you know, there's a thing called the reciprocal pension exemption, and other things that are like in my book. And yeah, I was just really surprised. But it makes sense now, you know, hindsight's 2020. International tax is a very, very niche area of law. There's a lot of people out there that say, oh, I'm an international tax attorney or international tax CPA. They have not had a single day of formal instruction in the classroom. They literally woke up one day and just said, hey, I think I want to try international tax. And I mean, you know, I studied 4 years on this, and you know, there's still, you know, some things that we run into that are really difficult and keep us up, you know, having to research. I can't imagine just waking up one day and thinking I'm going to take a crack at this. But you know, so there's a lot of people out there that are like that, and there's so much misinformation out on the internet. And then, you know, on top of international tax, in the international tax world, which is already a niche, there's another niche within that, and that's tax treaty planning. And that, I'll tell you, maybe 1 out of every 20 or 50 international tax attorneys actually know tax treaties. And so it's a niche within a niche. And so that's why it makes sense that a lot of people aren't really good at it. I mean, the IRS maybe has 4 people, tops, that are really good. And one of them was my professor when I was at Georgetown. Her name is Grace Lee, and she's retiring in 2 years, so yeah, it's gonna suck for them. But but yeah, I mean, there's I don't want to hit on the IRS, you know, but I sometimes feel a little bad because I know that they're constrained. Because, like I said, international tax is a niche, tax treaties is a niche within a niche, and law firms are willing to pay a lot of money to bring people on board that know that. And sometimes, you know, that is going to be far more than you would get on a government salary at the IRS. And so they suffer a lot from what we, like in the business world, call it brain drain, you know, which is that you can't compete. But that's a separate issue. I'm not going to advocate for them, but yeah, it's a very complex area of law, and it kind of makes sense that they missed it for so long. So, yes.
We got a letter from John Winners. We have no tax agreement signed in here almost 4 years now until this year. So we are being told that we have to amend. We don't do it in 2 weeks. Actually, we wanted it by the December. If we didn't amend our taxes for last year, that we would be charged $40,000.
Yeah.
on striking tax.
Yeah, I saw that letter. So two of our clients had already provided us with that letter. We sent an email over to John Winter, and we told
And
him.
he really suggested we had to do it right away.
I'm sorry?
We had to do it immediately.
Oh,
We
yeah.
weren't even in town when the letter came.
Oh, yeah, no, don't worry about it. So we already responded to both of them, and we told John Winter, look, just assess the tax, and I told him, I said, look, we're trying to be a lot more friendly about it now. We just said, look, there's a disagreement on interpretation of law. You don't think Article 19 extends to employees of private defense contracting companies? We do. The language is glaringly clear. Government-like functions. I mean, it's straightforward. That, by the way, sorry, I should have emphasized, that phrase has been used in other income tax treaties, and the uniform consensus is that that extends to private defense, or that extends to employees of private companies that are performing government-like functions. And in this context, the private defense contracting companies out here. So yeah, I mean, he can certainly do as he pleases and assess tax, but at that point is where we would step in and take legal action in Australian federal court.
So I would like to understand the process of how our filing in the United States even comes in purview of the AGO. Like, I mean, how do they find out that we're not filing, or that we're filing a solution?
Yeah.
So, yeah, I just want to know what that process is. Is there some kind of communication between the U.S. and Australian governments?
Yes, yeah. So it's Article 26 of the U.S.-Australia Income Tax Treaty. It's the Mutual Cooperation Article. In that one, it says that the governments shall cooperate with one another, especially in cases involving examinations. So the proper way for the U.S. government to share information with the Australian government is a formal request under Article 26. Then you submit that to the Internal Revenue Service, and then the Internal Revenue Service will send it to their legal department, who processes it. And then if they believe that the claim is valid and not retaliatory, they'll go ahead and provide that information to the Australian Tax Office.
Is there any requirement to notify a person from the IRS perspective that the AGO was asked for this information?
And that is the gray area. So under US law, whenever information is shared, there is a notice requirement. So whenever any information, for example, like when you apply for a mortgage, you end up getting that letter afterwards that said, hey, we shared your tax information with Wells Fargo Bank, or whatever it may be, or your information was shared with FAFSA, if your kids are applying for college tuition assistance or anything like that. But the big debate has been, what happens when there's a request from a foreign government? Isn't there a notice requirement? And the IRS's response was, well, we don't have a template for that. It's like, okay, we'll draft one. So it hasn't been resolved by a court yet, but that is something that we're going to address, because in the letter that she's describing that came from John Winter, he specifically says, we requested the information under Article 26, basically letting me know that we fully comply with the laws of time, don't come down on us, like I did last time. But he's basically saying, we correctly requested this information, we lawfully obtained it, and so now, we're threatening to assess tax. So now that we have that letter, that is something that we are looking at litigating, so that we can go ahead and take that before the United States District Court for the District of Columbia and say the Internal Revenue shared this information and didn't provide notice to the client. The problem with that is it really doesn't get us anywhere. I mean, I'm most likely, just because I'm very litigious, I'm most likely going to file a case anyways. But I mean, the judge is really just going to look forward and be like, well, you got that letter from John Winter, so you were effectively notified. So the question there is harm, pretty much, like where's the harm? But I think what we would have to try to argue is that it creates a chilling effect. Nobody really knows, how many more people have their information shared, and John Winter hasn't sent a letter yet. So yeah, it's like I said, it's a gray area, but it's something that we'll have to consider, putting resources and time into.
So if we go with your firm and get a letter like that, did you let you for us, or what?
Oh, yeah. Oh, yeah. I mean, we really,
Send them a letter from the back office.
yeah.
If fees pile up and say the interest and all of that, so while you're doing that, the fees and stuff is still going, and we don't have to pay them, we don't have to worry about it?
We would have to do.
Our firm is not, you don't have to worry about that.
Yeah. I mean, if it's the Australian, like, there's really going to be no fees. Like, if you're our client, we automatically provide that representation at no additional cost. And that's part of the insurance example that I explained, where we pull the resources together, and that's what we use to then cover all the Australian legal fees, so we can have law firms then working for you here and defend that locally.
So what about in the United States, if we get a letter, then you still take care of that?
Oh, yeah.
When you go through court?
Oh, yeah.
Fees still pile up though, right? I mean, the interest, fees, penalties, all that still piles up until all of this is done?
No, there's no penalties or fees. The
So
only
file later.
No. The only interest rate is it's about, like, I think it's 1.3% right now or something like that. It's incredibly low. But no, penalties are automatically off the table, because the only penalties that the IRS will be able to apply in that sort of situation would be the 20% understatement penalty or the 20% negligence penalty. But both of those require that you took a legal position that had no reasonable basis in law, and no judge on earth would ever agree with that. We wouldn't be out here if we didn't feel that our position was reasonable. And in this case, it's far beyond reasonable. I think the question is whether the IRS's position is reasonable, arguing that Article 19 doesn't extend when the language of the treaty is pretty straightforward.
So in other words, like you say, if this isn't settled for 3 years, so you didn't pay, or you had $20,000 or whatever for 3 years, then you would have no penalties except 1% if you haven't actually paid that.
Correct, yeah. So worst case scenario is you pretty much pay the tax you would have paid plus about 1%, 1.5%, or let's just call it 2% to be safe. Any other questions? Yeah.
Is Melanie Goodell still working at the IRS?
Big mystery. Reassigned, have not heard from her in about 2 years, or since pretty much the last time. Yeah, I mean, I can't, we have no definitive concrete information, but our understanding is that she's no longer employed in the Internal Revenue Service.
So what about a spouse earning Australian, paying Australian taxes with me making and paying American?
Yeah, correct. So, yeah, unfortunately, in that type of a situation, those would be standard. Is she an American citizen?
Yes.
Okay. Yeah, no.
I would join her.
Australian employee.
Yeah.
Australian employee.
Yeah, so that's where the general rule under Article 15. So Article 15 is all other wages. Article 19 is the governmental. Article 15 is the rule under international law, which is what was the geographic area where you were physically present when you performed the services giving rise to the income. And if that's in Australia, then Australia has primary taxing rights. And the US would then have residual tax rights. And so what that means is she'd have to file her Australian income tax return and report that, and then report that on her US return and claim either the foreign tax credit, or she could just claim the foreign earned income exclusion.
So that's what I did. But what with me, if I would go with the tax exempt. So I'm paying, she's paying her taxes here, and I'm going tax exempt.
Yes. Oh, so you mean, okay. Yeah, because Australia doesn't have joint income tax returns. Each person files their own return. So she would just report hers, and you wouldn't have to file
So
it.
I can't.
Any other questions?
She's a question.
Okay, great.
Hi, John.
What's your advice on the consent and disclose thing that we're being asked to sign as well as the closing agreement nowadays?
So the consent to disclose is, remind me again, that's the IRS saying,
It's where we're giving the IRS permission to inform our contractor employer.
oh, share of the company.
Tax problem.
Okay. Are they still requiring that?
Yes, sir.
That's correct. Okay. I mean, you can sign it. It's not a problem. They share the information. It's not a big deal. I think before the consent disclosed was mainly used as an intimidation tactic to try to discourage you. But all we needed was one case. We already had like 6 pending before the courts. So we're good to go on that. I mean, I would just say you can sign it. It's not a problem. I think it does more harm than good. And for the most part, like I said, last time I think it was really CYA of them trying to cover their tracks on the incorrect way that they had been sharing information in the past. But now my understanding is they're doing everything by the book because they know our firm is keeping a close eye on everything. And likewise, they're keeping a very close eye on everything that we're doing, making sure that we're doing everything procedurally by the book. So, but yeah, I would say go ahead and sign. It's not a problem.
I have a question. What is the class action suit that is on? Can you explain a little bit about that? It's on the.
Yes.
It's not up this, but I don't link to it.
Yeah, so we had originally filed the class action because we didn't expect the defense contracting companies to so blatantly lie in federal court. We're not necessarily lie, but well, sort of. I'll tell you what happened. So we filed that case because it was pretty straightforward that they had provided this advice that they told all of you had to sign it or you'd lose your job. When we filed the class action, all we needed was an admission from them that they had provided this, they had stated that, and that's pretty much it. We would automatically incur liability, and then we could have the U.S. Court of Federal Claims case and the tax court case run concurrently, and once it was declared that they were wrong, we'd automatically win the class action. When it got to court, they argued that pretty much, they didn't say, we never told them that. They just said there's no evidence on file that they presented that establishes that our client ever actually said that. And so we tried to ask them point blank, are you saying your client never told people sign or you're fired? And they said, no, we're not saying that. We're just saying you haven't presented any proof proving that. And so it was one of those things where, and I've actually used this phrase against people, and then it came back to bite me. It's not what you know, it's what you can prove. And so unfortunately, we didn't really expect that, which, we now have proof of that, but it was after the case got dismissed because the judge was like, well, you haven't presented any proof. We don't have it, and I don't think we can produce it in the next 30 days. So we decided that we were jumping the gun on that anyways. So that's where we decided the first issue is, let's get the tax issue resolved. Let's have a federal court make a final conclusive ruling. Yes, our interpretation of the income tax treaty is correct, and their position is wrong. And then we can refile the class action and then establish that they had provided this incorrect advice, and that's what automatically then creates the law.
I thought the class action lawsuit was tossed out for inappropriate that we're filing in the Northern District of Texas.
That was the first reason. We were trying to get it in Texas because Northrop Grumman, that's where they were headquartered. They then wanted it transferred to Virginia. It just basically became a big mess. And like I said, that's where we decided that to get it dismissed was actually a good thing because we needed to get the tax issue resolved first, because we couldn't go to court and argue that they had provided incorrect tax advice if it hasn't been established that the tax advice is incorrect. So it's really just our word versus their word sort of case. So basically, I'm admitting it was a flawed strategy. We shouldn't have followed that class action. It was a little bit too soon. But now, like I said, we decided to come back to the table and come up with a clear litigation strategy, what needs to be done based on the feedback from the court. And we got to get the tax issue resolved first. Then after that, we have to settle the issue in Australian federal court as well if the IRS decides, or the ATO decides to challenge on the Aussie side, and then that way we would have courts on both sides agreeing with us, and that's what then makes it conclusive and allows us to file a class action without either side being able to argue like, oh, well, that's just what the U.S. court said. You know, Australian court hasn't made a ruling on the validity or the legal status of the 1966 defense agreement, because there could be this weird scenario where the 1966 defense agreement is a valid treaty under Australian law, but not under US law. So that's an issue that is still being worked out.
Is there a statute of limitations on that class action suits that you pursue that in the future?
No, so the issue is that it's what they call it's not ripe yet, which means that there's been no determination that there was.
I'm fine with that. Assuming that in 3 or 4 years in the future, you bring up that class action suit at that time, when would I, assuming that I left that company in 2005, 2006, would I be eligible to be on the class action suit?
Oh yeah, absolutely. Yeah, and there's this rule called the discovery rule. Well, it's a mix of the discovery rule and another rule, but there's been no determination yet, again, that the tax advice was incorrect. And so when the court finally makes that ruling, and then let's say the IRS decides not to appeal that case, then that's when the statute of limitation time starts. And then we would have, arguably, I'd prefer to go for the lower end, 2 years from that time to then file a class action. So that's how that works, because it hasn't been determined yet that the legal advice was incorrect.
So closing agreement, sign it or not sign it?
Yeah, go ahead and sign the closing agreement. Yeah. It's, like I said, it's not valid anyways, and it appeases the companies, so, yeah. It's not an enforceable agreement. So that's the reason we're advising people to sign it, and that way it doesn't cause any employment issues. Do you have a question?
I just wonder, you know, I'm a spouse, so I'm not at the base, but I just wonder how they brought in, you know, we have these big companies, huge companies, some of them, and they all have legal advisors, and all these legal advisors are saying it is bad, you know, and then of course, you know, I think you're very well qualified, but why did they all say it's bad?
I mean, their careers on the line. They've been saying this for 33 years, so they look pretty bad if now they admit that they were wrong. And not only that, a lot of them are brought in as kind of a jack of all spades. So they handle mobility issues, state income tax issues, federal income tax issues, and then they're asked to handle international tax issues. You just don't do that. Every accounting firm in the US, every law firm, if there's an international tax issue, there's a very specific international tax person. And so, yeah, I mean, and even, like I said, even the ones that are international tax attorneys, like I said, only about 1 out of every 20 really know tax treaties, tax treaty law. And so, yeah, it's just, in their defense, it's extremely difficult to comply just because, you know, you got all these different issues to worry about. You know, you got domestic law of Australia, you got domestic law of the United States, and you got this defense agreement, and you got this income tax treaty. And on top of that, they also have to know all the state issues that are going on. So, yeah, I think a lot of them, like I said, just missed it. You know, we had never even heard of the issue before until we were contacted by Scott. So, yeah, it just went unnoticed. Yeah.
Have you ever dealt with Ernst & Young before?
Oh, yeah.
And have they ever been wrong?
Yeah.
Could you explain that? Because that, I think, falls into what she's saying, because I know a lot of companies out there who get their advice and their guidance from Ernst & Young. And
Oh, okay.
I never remember the name of the company, but.
Oh, yeah, a lot of times.
If they're wrong, tells me that this could be very true, that in fact they did wrong.
Yeah.
So,
Yeah, so, I mean, yeah, she pointed out right away, a superannuation, which I'll tell you about. But yeah, it's important to note that they're an accounting firm. They're not a law firm. They will, in their defense, immediately state that they employ more attorneys than most law firms in America. That's true. They have JDs, people with Juris Doctors that work for them. But again, their hiring strategy is quantity over quality. And so, you can put 100 people in a room, if they don't know what they're doing, they're still not going to find the correct answer. One of the most glaring issues that she immediately pointed out, that I was going to point out as well, is 7 years ago, our firm was the only firm in the US that had taken the position, and this is like a common recurring story. I'll give you a few more examples. We were the only ones taking the position that these things called Australian superannuation funds were technically privatized Social Security accounts in the United States. And before, everybody thought that these were like private retirement accounts. And so, KPMG had taken this position, Deloitte, Ernst & Young, Price Waterhouse, all the big four. And our firm came out, and after we did a lot of legal research, we concluded that these weren't private pension accounts, they were actually privatized Social Security accounts. And we didn't know that in America because we're used to the concept of government-run Social Security. The concept of a privatized Social Security account doesn't even register in our minds, especially as tax advisors. Because I'll be honest, before that issue came up, I didn't even know that there was any country in the world that had privatized Social Security accounts, let alone how it operated. And so after we very thoroughly analyzed the 1992 Superannuation Administration Act, that's when we came to the conclusion that this was actually a novel form of privatized Social Security, which meant that it was covered by Article 18, Paragraph 2, and made it exempt in the US. What pissed off the IRS is that there were some Aussies executives that had $1.2, $1.5 million in their superannuation funds, and they were starting to draw on this in retirement in the US, and the US just didn't like the idea that they were getting all this money and that our firm was taking the position that it was exempt from tax. To date, the IRS has not challenged us. Again, we can't litigate an issue until they rule against us and assess tax against the client. But that's an example where the big four, they've been wrong in the past. And I'm pretty sure, 20 years from now, there'll be maybe one or two issues that, we possibly lose on in court. I know when there's a legitimate risk of that, because that means that my confidence level would have to be around the range of 45 to maybe 60%. In this case, my confidence level right now is probably damn near higher than 90%. So I don't see it as an issue. But yeah, Big Four has been wrong before, including Ernst & Young. So it's not surprising. Questions?
One last thing, in the last meeting, we asked for this, and I don't know if you're doing this necessarily for all of your clients or whatnot, but how would your group feel about providing us perhaps some kind of monthly newsletter via email or something like that, either providing us with updates or saying there are no updates? No updates is a great update.
Yeah.
So I'm fine with that.
Definitely.
Something I want to request is in front of the audience and your group as well. We really appreciate that kind of stuff. Yes, I mean, we understand this takes very long, but to go months without hearing something just kind of makes everybody different.
Okay, yeah, well noted. So, Ismail. So this is Ismail Gross, our Director of Marketing. So that's no, we'll have to work on something. I know we were working on a template for a newsletter. We're also thinking of a newsfeed to send to you or something. But we'll try to think of something novel, maybe like a blog post that we can update or something like that. Yeah, we'll put something together, and that way we can at least once a month, have a note there just to send out an update, even if the update is saying, nothing's changed. Good point, thank you. We were wondering actually, if anybody would even want that. So we were debating whether to put time into it, because we were like, oh, well, nobody's asked for it, so yeah. Thank you. All right, so we'll probably start the open, let's go ahead and tell them to start the open bar. It's unlimited drinks, so please feel free to get as many as you want because we've already paid for it.
Do that for a bunch of Australians?
So just to give you a quick intro to the team that's here, this is Tiffany Michelle Hunt. She's our director of tax planning. She's most likely going to take the lead on case in the U.S. tax court. And also any filings and meta returns, she's actually the one that takes the lead on every single case. I review it pretty much right before it gets mailed off to the Internal Revenue Service. So she's familiar with everybody's names, all the filings and everything. This is Alexander Gomez. He's my executive assistant. He's like my shadow, so he knows more than he ever wished he would know about tax law. So actually, if you have any questions, you can definitely ask him as well. Our client relationship manager, Celeste Aguirre, again, she is kind of now the main point of contact for clients. We realized that sometimes, and our executive office manager, Alfonso Garza, we were sometimes getting overwhelmed with a lot of sort of day-to-day inquiries. Can I have a copy of my tax return? Can I have a copy of this? Is there an update on my case? And we realized like it doesn't really require like an attorney involvement. So for those type of things, that's what Celeste handles. So for the most part, anytime you contact the firm, so it's most likely either going to be Alfonso or Celeste. And then yeah, if you have any questions, you can also ask me. All right. Any other questions?
Jake, one question, and I apologize for the attitude in this.
Yeah.
Which members of the team up here are admitted to a state bar?
I'm admitted to Florida bar.
Florida?
Yeah.
Anybody else?
Oh no, there's all admin. So director of marketing, my assistant.
Catherine,
She's not here. She's
Yeah,
going
Catherine.
to Texas bar.
Yeah, Catherine Nahom again. She's with the Texas bar.
So the court cases you filed in the Court of Federal Claims?
Oh yeah, sorry. So she's licensed. So federal courts are a little bit different. You have to be licensed with each individual federal court. So she's. Oh yeah, so she's licensed with specifically the Texas State Bar, so that allows her to practice in any Texas state court. She's licensed with the United States District Court for the Northern District of Texas, and she's also licensed with the United States Court of Federal Claims and the United States Tax Court. Tiffany's licensed with the Florida State Bar and U.S. Tax Court. Yeah.
So if the jurisdiction goes to the DC Circuit or anyone else, who can argue there?
Catherine Nahom again.
Okay.
Yeah. Yeah, she would argue the case before the United States Court of Appeals for the Claims. Yeah.
Katie. Oh, and we have another attorney with the Alabama bar.
Yeah, so sorry. Yeah. Catherine Jean Barnes, she's the Deputy Director of International Tax. Yeah. And she's licensed with the Alabama State Bar and United States Tax.
Thank you.
All right. Any other questions? All right. Okay, well, let's enjoy some drinks.
Yeah.